morning, ladies and gentlemen. Welcome to this morning session on finding a way forward for cross-border data requests. Welcome to you all. For a start, I would like to point out or underline that I think this session is meant to complement the previous sessions, panel sessions that we had yesterday, one lunch session on law enforcement access and another one on the European production order. But the focus is broader. The focus of this session is definitely broader because it wants to go beyond the ongoing work of the Commission and beyond the mere European framework in this regard. We really want to focus on the EU-US dimension. I think most of you will understand why that EU-US dimension is so fundamental. My role in this panel will be very minor. I'm just chairing and I will be quickly giving the floor to the moderator and the distinguished members of this panel. But just a short word, what would be my take and what would be some fundamental questions that I would like to see addressed in this panel discussion. It will be rather a discussion. The purpose is not so much to have proper presentations, but we would like to have a lively debate with you, to engage with all of you in a discussion afterwards. So some of the questions that pop to my mind when I look at the title and the composition of this panel is, well, if we're talking about cross-border data, what kind of data? Are we only talking about communications data, or are we referring to a much broader category of data? Should we define that, or should we not? Requests from whom to whom? State to state requests, or would it rather be a state to private entity requests? What does that change? I think it may change a great deal, especially when it comes to safeguards. Third question that I would like to see addressed is territoriality. It was discussed at length, I think, yesterday in both sessions, I think. But then my question is, what defines territorial jurisdiction? What's your nexus? What's your link? Is the fact that you have a service provider that is established in your country, is that enough? Is it the fact that you have a subsidiary, is that enough? The location of data, should it really matter? To what extent? Or should we rather focus much more on the data subject? And then a last question, very difficult one, I think, is what's the relation between the data protection legal framework and the much more criminal law legal framework? To leave aside, because I'm not an expert in that field, surveillance law, but we could actually complement it. What's the relation between those different legal frameworks when it comes to cross-border data access? Okay, enough from me. I'm quickly going to give the floor to the moderator, but let me first present to you our distinguished members that we have on the panel. To my right, we have John Frank, who is the Vice President for EU Government Affairs at Microsoft. He was previously Vice President, Deputy General Counsel and Chief of Staff at Microsoft Corporation in Redmond, Washington. From 1996 to 2002, John led Microsoft's Legal and Corporate Affairs Group for Europe, the Middle East and Africa, focusing on issues such as privacy, security, and consumer protection. On my left, sorry, I was taking your perspective. I have the organizer of this wonderful panel session, Neil Richards. Neil Richards is the Thomas and Carol Green Professor of Law at Washington University School of Law, where he co-directs the Washington University Institute for Policy in Medicine and Law. He's also an affiliate scholar with the Stanford Center for Internet and Society and the Yale Information Society Project, as well as a fellow at the Center for Democracy and Technology, a member of the American Law Institute, and a consultant and expert in privacy cases, including the Schrems II case, in which he served as an independent expert retained by the Data Protection Commissioner of Ireland. Next to Neil, we have Ralf Sauer. Ralf Sauer is Deputy Head of the Unit of DG Justice Unit on International Data Flows and Protection, and has been one of the key negotiators of the EU-US Privacy Shield. Before joining DG Justice, he worked for almost 10 years in the European Commission's legal service on antitrust, state aid, and anti-dumping cases. And to my extreme left, we have Eduardo Ustaran, who is a co-director at the Global Privacy and Cybersecurity Practice of Hogan Lovells. He's duly qualified English solicitor and Spanish abogado based in London. Eduardo advises some of the world's leading companies on the adoption of global privacy strategies and is closely involved in the development of the new EU data protection framework. He has been named by Revolution magazine as one of the 40 most influential people in the growth of the digital sector in the UK and is one of the leading privacy and international lawyers in the world. And then with us on Skype, good morning, good night to you, Jennifer Daskal is an associate professor at American University Washington College of Law. She formerly worked as the counsel to the Assistant Attorney General for National Security in the Department of Justice and has written, as we all know, extensively on these issues involving cross-border access to data. I quickly hand over the lead of this panel to Neil.
Thank you, and thank you all for coming. I suppose I should reverse introduce our chair. Vanessa, Franssen, is a professor at the University of Liège. She works on many of these issues, focusing particularly on cybercrime, criminal law, and financial criminal law. What we wanted to do was to have hopefully a freewheeling discussion among these issues, cross-border government access, particularly across the Atlantic, that we may want to get into across the English Channel with the incipience of Brexit. It might be helpful for each of the panelists to take sort of 3 to 5 minutes, and really no more than that, to stake out some ground. I know a lot of people on our panel are particularly interested in the Microsoft Irish warrant case that is currently pending before the United States Supreme Court. So maybe we'll start with John to talk a little bit about that, and we'll proceed from there.
Good morning. As one begins to delve into this area, it's very easy to move to people constructing the world they would like to see. And sometimes our views about what should be then define the positions we take about what is. But if you think about an architect and an engineer, you may design the house, and then you have to figure out how to build it, right? And you build it on your existing foundation. And our existing foundation in international and national laws are essential here. We can't just wish away the fact that territoriality is the foundation of our international legal system. Now, we can virtualize above that, but to do that requires agreement between nations. One nation can't just unilaterally change international law, but by agreement, people can get to a different result. And so I think, every country, you've got a security privacy dimension that's pretty well discussed and a mature process where you have constitutional protections against, searches and seizures, going back in the United States Constitution to the Fourth Amendment. And other countries have dealt with that similar issue. When we start adding the cross-border aspect of it, you've got sovereignty issues as well, and international law being implicated. There, we've had less experience, in fact, very little experience, trying to adapt. Well, actually, I'd say we've figured out how things would work, except now the digital world seems inconvenient. So, it's great, and it's interesting to talk about the world we want to be, but we can't run away from the fact we've got to build the future on this existing foundation. Now, the Microsoft case began with the observation that the U.S. statute was not extraterritorial on its terms. And under United States jurisprudence, the court has generally said that a statute that's extraterritorial creates international conflict. And it's not a judgment about that courts are well suited to make about whether or not to interpret a statute to create that conflict. And so therefore, the court will look to see, did Congress intend this to be extraterritorial? And so the basic argument in our case from a lawyer's point of view is that the Stored Communications Act, written in 1986, did not contemplate being able to reach data stored outside the United States. Now, the goal of the litigation is to get Congress to update the law and to adapt to the new world, but you have to start with the existing legal foundation. And so I think the case, just last Thursday we had 23 amicus briefs filed in favor of our position, 9 of them from European entities, including the European Parliament, or members of the European Parliament, but it also included the heads of the 4 major political parties, privacy groups, the broad business associations, the tech associations, and sort of civil society. So there's a wide range of people coming forward saying it causes conflict when one country reaches in to the European Union and ignores European privacy rights and to get data. The anticipation is there'll be legislation in the United States if we win, and the legislation will be structured so that it can accommodate international agreements on a reciprocal basis. And so that's the goal, so that we can have a legal framework that not work. It's important that it works for law enforcement, but it also has to work in an era of cloud computing for customers, citizens. Because I think one of the things we learned from the Snowden thing was it was great for the United States to say, don't worry, we only spy on Americans, or we don't spy on Americans, but that left 96% of our customers outside the United States concerned about what was happening to them. And if the US government only cares about US citizens, that makes it clear that other governments have to look after their own citizens. And so we're in a world where there's equities of protecting one's citizens that are very important, and customers are concerned about governments reaching cross-border. And so we need to figure out how to accommodate the territorial system and get to a result. And I think the European Union is an excellent place to do that with the upcoming e-evidence proposal, which has been delayed. So with that, I'll turn it back.
Thank you, John. Ralf?
Yeah, thank you very much, and good morning to everybody. I was mentioning the evidence proposal, but I'm a bit limited in what I can say about that, as you will understand. That's why I want to focus a bit on our intervention in the Commission's intervention in the Microsoft case, and a bit what conclusions one can draw from that, that may also maybe the last conclusion from that, and that's also something which you'll find in the intervention, international solutions to this problem are probably preferable. Because that's the best way to deal with the committee question and find a solution which works for both sides. As you know, there is ongoing work on the Convention
key ones here are legitimate law enforcement interest in accessing data relevant to serious crimes that occur on one's territory or affect one's territory. The legitimate sovereign interest in protecting the data of one's own citizens and residents, which I think stems both from a normative interest in protecting basic rights and a practical interest in ensuring that even if data is being accessed that's not with respect to one's own citizens and residents, it's often intermingled with data of one's own citizens and residents, and that provides, I think, a link to the third key sovereign interest, which is ensuring that all requests meet basic, fair process, fair substantive requirements. And here, I think, with respect, first on a potential legislative solution on the Microsoft Ireland issue, I think there's potentially some hope that there will be some movement within the United States on this, although hope springs eternal when one deals with the U.S. Congress. But in my view, I'd like to say that I think there's an increasing number of stakeholders, including some who have introduced pending legislation, that recognize basically a more or less default rule, but with important caveats, that if the U.S. government is seeking data from the U.S.-based provider pursuant to a warrant issued by a judge pursuant to a probable cause finding, then that data is generally accessible. But if the United States is seeking the data of a non-citizen located outside the United States,
to the extent that any interference with what is supposed to fundamental rights with data protection exists, that interference has to be proportional, has to be necessary. And I think whatever mechanisms we put in place in order to overcome that, to address that balance, to try to find a compromise, if you want, between the restrictions and in terms of the protection of data and the ability to comply with government action requests, they always need to go through that filter. Whether you're talking about contract, whether you're talking about rules, whether you're talking of some kind of disclosure protocol, and we can talk more about that and my experience in the UK about disclosing data to law enforcement. And it always has to go through that filter of necessity and proportionality. And I think that's the way in which the direction in the solution needs to be found.
That was admirably concise. So we've talked a little bit about we've talked a lot about the Microsoft Ireland case, right, in which the law enforcement authority is in the United States, the service provider is in the United States, and the data is in Europe. The Schrems 2 case flips the facts a little bit, right? So in that case, you have allegations that the data subject is in Europe. The data starts in Europe and then is sent to Menlo Park in California for processing. And then at some point or points along the route of transfer, whether in the United States or under the ocean, the US government accesses the data. I'm curious what the panelists think about that set of facts, how that changes our perspective on questions of cross-border, and maybe what they would like to assume there is a reference to the ECJ, what they would like the ECJ to do with it. And I suspect Ralf would say don't strike down the privacy shield. But sort of beyond that, if the privacy shield is struck down, if Schrems prevails again, in what ways could the judgment be helpful to build something sustainable, useful out of the situation? If you'd like to, it's not necessarily. I mean, I can put you on the spot. I suspect you always find it fascinating, but I don't want to do that. Okay, good.
I'm happy to pick that up.
Okay.
This is a good principle, the rest of the world does that provide that balance? So what about the international data transfers, which are legitimized by way of another process, when the data is not sent to the US but to anywhere else in the world? Does that mean that the US becomes the only state jurisdiction which, if you use another process or some kind of mechanism, the data can flow to, but the rest of the world doesn't, unless it's adequate, like Japan, soon? Then that is the challenge we need to resolve, and I think the way, once again, the way to resolve that in practice is to ensure that the mechanisms being used, whether it's a smaller process or some data disclosure protocol or anything like that, has that ingredient, if you want, that additional mechanism of necessity and proportionality. And just very quickly, as an example, when in the UK, the Metropolitan Police, or any police force for that matter, request access to data from a company, they would issue their own already signed data disclosure protocol. And they will say, we have considered already the need to access this data. We know it is required for this particular investigation or to apprehend offenders in a particular case. And it is for that reason and in that context only that we are requesting this data. And the company will say, oh, here you have it. And that is a discussion that has been had, in a sense, in the past as to what the limits are. And the law enforcement authorities are operating within those margins. And that is a discussion that probably needs to be had in the context of organized data in other jurisdictions. But that's the way in which, I guess, commercially and practically, you try to find the balance.
So what would that look like in terms of a contract with an element that satisfies necessity and proportionality in your view?
So for example, a data disclosure protocol is a two-page document which is essentially an undertaking by whoever is requesting the data, normally signed by a police officer, that says, we as a police will undertake to protect this data, to comply with the laws, we only use it for this, we believe it is, you may indeed disclose it to us on the basis of this specific provision of the Data Protection Act, and so on. And it's an undertaking that from the
can I just perhaps talk about how we have a new framework within the European Union? I know you can't talk about e-evidence because you know more about it than I do, but even though I don't know what's going to come out, I can talk about the basic ideas and what we'd hope to see. And it goes back to, at the beginning though, that like data, it may be global, but always it has a location. It is somewhere, right? Because when you open your email, it finds its way to you, and your computer found it pretty fast. So data always has a location, but sometimes, for a variety of reasons, it's not in your local country. And so I think within the European Union, for the member states to agree that, look, if there's a Belgian court order relating to a Belgian citizen or somebody habitually resident there, if the data is anywhere in the European Union, the service provider should be able to provide it to you. I think most people would say that protects the equities pretty well. Because Ireland, if it's a Belgian citizen, it's a Belgian court order, and the data's there, I think they would say, yes, we have a sovereign interest in this data, but by agreement, we're going to mutually recognize a Belgian court order. And I think that basic step would take 90% of law enforcement needs and address them in a way that law enforcement felt they could get data quickly and efficiently. And I think most citizens would say, you know, that's fine. You get to more complicated cases when, you know, okay, it's a Belgian court asking for information about somebody who's not a Belgian citizen or habitually resident there, but is a resident of Germany. Then the German government has a little more interest, and so maybe you need a notice provision or you need something, but I think you know, people around the table can kind of say, well, it's reciprocal. What do I want? What do I think is appropriate both ways? But I think the first case is quite easy. The second one gets a little more difficult. But just the data stored within the European Union, the member states, I think, are free to agree to this protocol. Now, certainly as a service provider, I would, you know, we've always had a policy. If law enforcement comes to us, we will tell them where the data is. We're not trying to hide the ball here. This data is in our Dublin data center. This data is in our Amsterdam data center. This is in our Finnish data center. We will tell you. And the group of data, we talk about email, but you know, for a lot of companies, it's their, you know, their major databases, or for governments, it's, you know, it can be repositories of large amounts of documents. So a wide variety of data is involved here. But, you know, the basic idea of setting a system where, yes, it does have a location, but we can, I talked about virtualizing a virtual machine kind of concept in computing, but you know, we will, you know, you should be able to come to us, one place. We should be able to get it anywhere in the European Union. The next complication, though, is if it's not in the European Union, and then you've got a bigger challenge because the United States has essentially a blocking statute saying that we can't provide that to you from the US. And while Article 48 of GDPR is not a blocking statute, it is a pretty strong presumption against being able to serve an order. So we need an agreement between the US and the EU on what those circumstances should be. And again, it's sort of people sitting down and saying, well, our privacy equities are thus. We want our privacy rights respected, so we want notice. And you know, when should there be notice? What opportunity should there be to appear? And how you're going to have that sort of conflict resolution discussion. And we need to be able to do this at relatively high volume because you know, we anticipate over time that there's going to be more and more of these. So, but if we think about starting with the simplest proposition, I think you could get agreement. I think you could get European Parliament support. The further you get away from that, the more complications you get, and the more additional equities get mixed into the decision-making process that lead to, I think, more controversy and less likelihood of speedy passage to the European Parliament. But that's something for the Commission to take into account as they put together a proposal. But I think that most of us would say, you know, again, where I began, look, I think about the foundation that we're building on, but also thinking about where we want to go. And I think most of us agree on some places that we could go that would solve problems. But sometimes we want to skip the steps of, well, how do you build it there? And that's often where some of the disagreements are.
Jen, do you want to add something?
I actually agree with that. I think just a brief comment on your trust point, which just it's a fairly obvious comment, but just the ways in which the analogy is apt, and just thinking about the ways in which the interconnectedness of data, both in the commercial sphere and in the law enforcement sphere, are and should put pressure on the countries and to begin to think about harmonization standards the way that meets basic clear process human rights standards with respect to both procedures and substance, but does so in a way that also continues to respect the national differences in this regard. And at the broadest level, the key challenge here in both of these realms.
If I may just throw in one word, I would like to follow up on what you said, John, about the data is always located somewhere, but it finds your way to your computer. I open my computer, and it doesn't matter to me whether the document is saved on my computer, on a local server here in Belgium, whether it's saved somewhere in the cloud, and often, when it's saved in the cloud, I don't even know where it is. So I see where the problems and the requirements of data location come from, and I'm very much aware of that. But I think if we want to protect fundamental rights, I think we definitely need to gear more towards a subject approach. I mean, my fundamental rights, I expect them to be protected where my interests in that protection are. And I'm not sure whether the location of the data, which I don't determine very often, should matter all that much. I mean, my expectation to a protection is based on where do I reside, where do I usually reside, what is my citizenship perhaps, or where am I traveling to? If I'm traveling somewhere and I'm committing an offense while I'm traveling in that country, I can expect to have the law enforcement knocking on my hotel room door and to come and search my hotel room. So including what I have on my computer, including what is accessible. Does that mean that all my documents that are accessible for years and years through my, I don't know, email account or through Dropbox should be accessible? That's a different ballgame. But I think we should much more gear towards what is the individual expecting and what kind of a protection is he or she expecting. Don't think data location should weigh as much as it is.
Yeah, I think to the points of both of you just made, I think something which I think is important to appreciate is the shift we're seeing in European data protection. In terms of, I think we're moving away from the law around the location of the data. And if you look at the 1995 directive and the way in which the Americans. I'm not American, I'm only state. We don't have the same constitutional protection as Americans. I guess for historical reasons. But the European approach is we protect people who are in Europe. And when you think about that, it's a very universal way of looking at it, because the moment you are, it doesn't even mean you don't even need to live in Europe. And it's not about where you residence, you just are in Europe, and then the law protects you. And what that, to me, that means is that we're going towards that more universal approach of protection, which starts to step away from the location of the data. And conceptually, I think it's something that we need to bear in mind.
I think it's, well, here's where I think that, you know, we all agree that in the future world, the data location shouldn't matter because I want my protections. And in a sense, the GDPR provides you that because it says that your data can't be transferred outside the European Union where you've got a certain set of protections without a lawful basis, right? And that's your protection. And in international law, we talk about two kinds of extraterritorial jurisdiction: prescriptive extraterritorial jurisdiction and police jurisdiction. Now, the GDPR has aspects of extraterritorial prescriptive jurisdiction, same as antitrust laws do. It says you can't set up a cartel just across my border and have effects in my country. That's a violation of my law. So we have extraterritorial prescriptive jurisdiction fairly frequently, and we work on that because it does serve to provide a broader set of protections. But on police jurisdiction, that's an area where you're exercising police powers, which is exercising a search, or that is something under international law which is quite clear that it's based upon where the activity occurs, which is the data. So we can have both places, but I think, and the way to deal with that though is by agreement between countries. And I think that, just going back to my earlier point about a US-EU agreement, I think ideally, again, that Belgian court should be able to get data stored in the US based upon a Belgian court order. But it needs to there's going to be notice to the US or some provision like that. And there just needs to be taking into account the system has to work for other countries as well.
It's a really interesting development in our discussion. One of the more famous lines in American Fourth Amendment law is actually that from capacity, the Fourth Amendment protects people, not places. And that, as we look towards these sorts of agreements, I think the interesting and important questions we have to work on are probably, what are these cultural issues? What should the key foundations of the regime be? How much of a focus on data should there be, on location should there be? How much of a focus on individual rights and citizenship? And beyond that, what should the substance of the individual rights be? I know in our conversations, did you think quickly on the agenda? I want to get audience questions.
I did just one comment on U.S. law, because I did want to just clear up any misperceptions about U.S. law. At least for U.S. criminal procedure rules, they don't vary based on for people they apply universally to people within the United States. So constitutional criminal procedure protections in the United States protect both U.S. citizens and non-U.S. citizens who are located in the United States. And then I just wanted to respond to the discussion about the distinction between prescriptive jurisdiction and enforcement jurisdiction, and I absolutely agree with the premise, but not necessarily the conclusion. So the premise is that enforcement jurisdiction is historically been territorially limited for good reason, and I agree with that. The question here, though, then becomes, which is still the fundamental question that I think we're still struggling with, and the Supreme Court's going to be forced to provide some answer to by the end in the next several months, which is, what is a territorial exercise of enforcement jurisdiction in this space? Is it based on where the data is located, as Microsoft claims, or is it based on where the provider is located or where the data is disclosed? And those are two very different answers, both starting from the same basic premise that enforcement jurisdiction is and should be territorially limited.
And there's a microphone stand. Looking for an orderly queue.
Yes, Joris van Hoboken from the University of Amsterdam and Vrije Universiteit Brussels. I have a question that actually follows up on that last point, which let's think about the possibility that Microsoft loses the case. No, and that the outcome of the case is that even though the data is stored within the European Union and a transfer to a third country has not taken place, we lose the protections, like from the European perspective, that should be in place, you know, like that the GDPR really cares about, and that all the rules about transfer, you know, to third countries are trying to prevent, you know, that kind of the closing that kind of loophole, the protection is and really assuring that there is this effective protection for people within the European Union. So what does that mean for the European framework, and does that mean that all those rules about transfer are just there's really the wrong proxy? That is really not the point where you lose the protection. The point of losing the protection is already happening much earlier because of police jurisdiction kicking in for data that is stored within the EU. So how can that be resolved? Would that need to lead to need to update the GDPR on that point, or are we going to see another resolution?
You don't really lose your European protections just because what a U.S. court says, right? It's just the U.S. court can't change European law, and so it does put companies in a conflict of law position. There's no doubt about that. And just one element, on the case. I mean, this case doesn't just apply to American headquartered companies. It applies to any corporate family that has a member company that provides electronic communication services in the United States. And so the service provider in this case is Microsoft Ireland Operations Limited. They're the ones who provide the email service, and it's, you know, but they serve the U.S. affiliate, Microsoft Corporation. You know, Deutsche Telekom, if they've got a subsidiary in the United States providing email service, in theory, this would say that the Department of Justice can demand data not just of an ECS customer in the United States, but a customer anywhere.
Prevent or inhibit the transfer. That is not a given, and Thank you. Christian Svamberg, I'm the Chief Privacy Officer at the Danish National Police. So maybe just to add a law enforcement perspective, we do believe the US is democracy, just to clear that out. I think everyone would agree that this is basically an issue that has been created due to the advancement of technology, the advancement of the internet, cloud computing, as Mr. John Frank has said. We didn't invent this as law enforcement. It's not that we got this bright idea that we wanted to all of a sudden step outside of the bounds of MLATs and start getting data in new creative ways. We're basically being faced by a vast amount of new criminal activity that affects our citizens. And that's what we care about. And on that basis, I maybe want to challenge the panel a little bit on this constant reverting to nationality and territoriality as in some way being the determinative factors in the jurisdictional question. Because this is obviously, it is a conflict of law, but isn't the conflict more in regards to criminal law? Because under international criminal law, one of the more fundamental principles of international jurisdiction is the protective principle, which is actually the one we care about, i.e. a crime has been committed that affects our citizens or an individual in our territory or has been committed by someone within our territory. And then we really don't care about anything else, because then we have criminal jurisdiction, and then we try to follow sort of specific procedural rules to get evidence that might be relevant. Obviously, the issue now created is traditionally we would then use the assistance of the other competent authority to get the data. But I think that what is often lacking is that we need to recognize that the actual tension is between criminal jurisdictional rules and then data protection jurisdictional rules that have just been drawn up, as Eduardo said, based on how these rules should apply. But we need to recognize that the reason we're asking for this data is that technology has now enabled crime to be committed in a way that is much more easy to do internationally, and our ability to secure evidence needs to move a lot faster than it would have, than it can do in any other way. And just one final point is, also important to remember, MLATs were not created to protect privacy originally. MLATs were created because traditionally, like 50, 60 years ago, it was very difficult to get international legal assistance between competent authorities. It was very, under the rules of international comedy, that took a lot of time. So you created these rules to alleviate the bureaucratic burdens, and then you added over time some guarantees in that rules, but it was originally something that you created to facilitate more easy exchange of evidence for criminal cases.
Just a very short reply on the protective principle from a criminal law perspective. I know it applies, but it's a basis to allow for extraterritorial jurisdiction, and only, as far as I know, in limited cases when it comes to serious crimes or crimes that affect, for instance, your currency or your national security. But to apply that in a general way and to say any crime that has committed against my citizens, let's say an online fraud scam, and it affects a number of Danish citizens or Belgian citizens or whatever, doesn't necessarily mean that Belgium or Denmark would have criminal law jurisdiction. It may have, but not necessarily, because it's extraterritorial. And as Jen said before, what is territorial? What is extraterritorial? So to say the protective principle is what applies generally in criminal law, I think that is too far a stretch. I think it's limited to a number of offenses.
Can I just jump in for a second, Neil, if I may? I think the question also illustrates a key tension between prescriptive jurisdiction and enforcement jurisdiction. So states often have laws that reach criminal activity that involves either activity or nationals outside of their borders. But that doesn't, at least in putting aside the digital world, that's never meant that the states can actually, that's why we have extradition treaties, that's why there's limits on states actually, agents actually going into another country and unilaterally searching or seizing. So I think the fact that there's an interest doesn't necessarily mean that access to data ought to be guaranteed. That said, I think the point is an important one, that citizenship and location of the subject should be factors and not always necessarily the key determinative factor, but they're definitely factors to consider when trying to think about how to translate the relevant equities that have played out in the equivalent conflicts that emerge with respect to issues like extradition and accessing more tangible evidence with respect to data.
I think it's important that law enforcement be able to get the data it needs. But I think law enforcement needs to work with us on a system that also works for customers. The Danish Parliament's data is stored in our cloud. I don't think you want a system so that, you know, a government in the Middle East who decides they don't like some Danish act and declares it a crime because the Parliament said something, to be able to serve unilaterally on us orders to get the email of the Danish Parliament, right? We need to figure out some protective rules as well, but it is important. We recognize that getting data to fight crime and keep people secure is hugely important. But we need to work on a system that can work for everybody.
On that note, I'm reminded of what John said at the beginning, which is that we are, in a real sense, building the world that we want, but living in the world that we have. I think these are tremendously thorny and complicated questions, but they are really some of the most fundamental questions we face, not just as a society, but as a civilization. As we build these transnational rules, we balance government power and civil liberties, and different transnational understandings of what those civil liberties are, and whether or not they're universal or not. These are issues we're going to be confronting for the next several decades at least. I think it's important for us to work hard on these questions. I think that cases like the Microsoft case and the insurance case have highlighted these questions in ways that we can think through them as lawyers in hopefully constructive and helpful ways. So I'd like to thank my panelists, particularly Jen, who is started at 2:45 in the morning. Thank you, Jen.
Thank you.